Good morning, everyone, and welcome to Gresham Chapel here at Woodward Academy for day 2 of our Supreme Court week. I'm your anchor and host, Brian Keith Jackson, and to my left I have my esteemed colleague, former ACLU lawyer, Ms. Maggie Berthume, and to my right here in the studio I have another esteemed colleague, former government attorney, Mr. Bill Batterman. Today you're going to observe a couple of simulated Supreme Court cases. We have 2 cases on the docket today. The first case you will hear is called Evans versus Michigan. The second case you will hear is called Arkansas Fish and Game versus the United States. Now, here's how it works. The students from my government econ class for the last few months have been writing, researching various Supreme Court cases. Those students will argue the cases before the Supreme Court. Following, the Supreme Court will then hear the second case, and following the second case, the Supreme Court will adjourn, deliberate on those 2 cases, and we will come back to WA Live Court TV studio and discuss the case that we just heard. Now, as a preview, counselors, let's talk about the cases that we're about to hear today. Let's start with you, Ms. Berthume. Tell us about the case we're about to hear, Evans versus Michigan.
Evans versus Michigan is a case that hinges on the question of in what circumstances the double jeopardy clause applies. Meaning, in this case, the trial judge made a mistake about what was required in order for the prosecution to prove their case. And then, as a result, the defendant was acquitted mid-trial when the judge felt the prosecution did not prove their case.
Okay.
As it turns out, the judge made a mistake. The prosecution was not required to prove the elements that he asked, and the state of Michigan would like another try at being able to prosecute Mr. Evans.
Doesn't that violate the double jeopardy clause of the Fifth Amendment?
Well, we certainly think it does at the ACLU. The state of Michigan is going to argue that because the jury did not have a chance to deliberate on the facts, that this was not an evidentiary ruling, but a procedural ruling, that there's a difference. We think that that distinction is specious and confusing for trial courts. It will actually increase the likelihood of court errors rather than decreasing it.
Well, I'm sure that the state of Michigan will probably think otherwise, and we'll hear what they have to say.
I'm sure they will.
Okay. All right. Now, Mr. Batterman, if you would, you are a former U.S. attorney. Give us your take on the Arkansas Fish and Game versus the U.S. I'm sure that some of the people who are arguing for the U.S. side are your former colleagues.
Former colleagues. They've got a tough job ahead of them. The United States government, in this case, is trying to justify some flooding that it caused in an area around the Mississippi River. The Arkansas Game and Fish Commission says that the government should have to compensate the landowners for flooding their land. The government is going to argue that because the flooding is only temporary and not recurring, and because it wasn't intended as an outcome of what the government did, that they should not be forced to pay back the Arkansas Game and Fish Commission. This one seems very likely that the Supreme Court is going to side with Arkansas
why is that?
And make the government pay up. The distinctions that the government will try to draw are probably not going to hold water in front of the Supreme Court. The takings clause of the Fifth Amendment seems pretty clear that when the government destroys land, it has to compensate the landowner. And even though the flooding is temporary, it seems pretty likely that they'll decide that that is the destruction of the land.
Even if it's only temporary?
Even if it's only temporary.
Oh, I thought the taking had to be permanent before you can argue that you deserve just compensation.
That's the issue that's going to the court will have to deal with. The interesting and the more difficult thing for the government to defend here is that some of the temporary flooding has caused permanent damage to the area. The timber farm and wildlife habitats have been destroyed, and so even though the Arkansas Game and Fish Commission still owns the land's value is substantially decreased, and so they're seeking compensation.
All right, well, we'll see what the lawyers will say about that. All right, now, it seems that the Supreme Court will soon be in session, and so what we're going to do is we're going to turn our attention away from WA Live Court TV studios, and turn our attention to the court as they hear these cases and deliberate following.
All rise.
You may be seated.
The United States Supreme Court is now in session. The Honorable United States Supreme Court Justices presiding. The two cases on the docket today are Evans v. Michigan and Arkansas Fish and Game versus the United States.
Is the attorney for Evans ready to proceed? Is the attorney for the state of Michigan ready to proceed? Attorney for Evans, you may approach the podium.
Hello, I'm Garrett Snyder, and I will be representing Mr. Lamar Evans. The state of Michigan charged Mr. Lamar Evans with the burning of a vacated house. Mr. Lamar Evans was found innocent on account of the judge's erroneous decision to make the prosecution provide evidence that was not required for the judge to hear or that was able to be required in the case. But this evidence did prove my client's innocence. This evidence that the house was vacated. Now the state of Michigan is trying to charge my client with the same crime, which is a clear violation of the Double Jeopardy Clause, as it says, shall any person be subject for the same offense to be twice put in jeopardy or life and limb in the United States Constitution. The Supreme Court has previously ruled in Smith v. Massachusetts that when Malvin Smith was charged for illegal possessions of firearms, the judge was unaware of the length of the firearm and pronounced Mr. Smith innocent. Then the state of Massachusetts tried to recharge Mr. Smith, but the Supreme Court claimed it was a violation of the Fifth Amendment because the judge did not have the proper evidence. They were charging for the same case, like the state of Michigan, with Mr. Lamar Evans. This is a violation of the Fifth Amendment, Double Jeopardy Clause, because you cannot charge with the same crime in the same case more than once. I would like the Supreme Court to acquit my client, Mr. Lamar Evans, from all charges. Thank you.
Counsel, if I can have a question. You mentioned in the case that you cited that there was an evidentiary difference as far as acquitting the defendant in that case. However, it seems that in this case we have an issue where there's an actual element of the case that the attorney is forced to prove, which is not an element of the crime. Do you still, with that in mind, consider it double jeopardy if your client were to go through this trial process again?
Well, Mr. Lamar Evans was charged with burning a vacated house. The judge asked the prosecution to provide evidence that the house was vacated, and the prosecution could not do that. So Mr. Lamar Evans, my client, was provided with acquittal. And then the state of Michigan is trying to recharge him with burning of a vacated house, which is the exact same crime, a violation of the Double Jeopardy Clause.
Okay, now if the terms of, or if the element of a vacated home were removed from the process and a court were to find that there's enough factual basis to charge your client with that crime, would you at that point feel your double jeopardy rights would be violated?
I don't feel that necessarily pertains to my case because Mr. Lamar Evans did burn a vacated house, and the house did not have any residents in it. And under Michigan law, that was not illegal at the time.
Thank you, counsel.
Thank you.
Attorney.
Hello, I am Clay McMillan, and today I will be representing Michigan in Evans v. Michigan. On September 22, 2008, two police officers from Detroit, Michigan, Officer Owens and Officer Davis, went to investigate a burning building. Once near it, there was an explosion, and they saw Lamar Evans deserting the property with a gas can in his grasp. After being told to halt, Evans disregarded the officers' commands and continued to attempt to flee, but was eventually apprehended. Once caught, Evans told the officers the burning down of the house was a mistake. After further investigation, the burn patterns that investigators found suggested that there was flammable liquid accelerants poured all throughout the house, leading the team to conclude that Lamar Evans had committed arson. At the time period in which the house was burning, there were no inhabitants living in the house, and there were no gas, electricity, or water services in effect. In the Wayne County Circuit Court, Lamar Evans was charged with the burning of other real property, which is defined in the Michigan Penal Code, Section 73, as any person who willfully or maliciously burns any building or other real property, or the contents thereof, other than the property of himself, shall be guilty of a felony, punishable by imprisonment in the state prison for no more than 10 years. The trial judge inaccurately added another element to Lamar Evans' offense by additionally requiring the state of Michigan to prove that the building Evans was accused of burning was not a dwelling. After adding the additional element, Evans' motion for a directed verdict was granted. Then Lamar Evans received an order of acquittal, and the case was dismissed because the prosecution had failed to prove the additional element to Evans' offense. The trial judge basically ignored evidence proposed by Michigan that would prove the elements involved with the crime. When this was brought before the Michigan Court of Appeals, the court reversed the trial judge's order granting Lamar Evans' motion for the mid-trial directed verdict and sent the case back to the court. The Court of Appeals alleged that the trial court had made a mistake when it required the state of Michigan to prove that the building Evans was accused of burning was not a dwelling in order to convict Evans of burning other real property. Furthermore, the trial judge made the mistake of not considering Evans' culpability to any of the elements of the crime. The Court of Appeals concluded with the fact that Lamar Evans was essentially never even acquitted of the original charges filed. Therefore, while the double jeopardy clause for both the U.S. and Michigan constitutions bar defendants from being prosecuted for the same offense following acquittal, the Court of Appeals concluded that neither of these applied in Evans' case. The issue is whether or not the double jeopardy clause will permit Michigan from retrying Lamar Evans when a directed verdict of acquittal was established on the prosecution's failure to provide sufficient evidence to prove a non-existent element to the offense by which Evans was charged with. The double jeopardy clause of the Fifth Amendment to the United States Constitution simply means that one cannot be prosecuted more than once for committing the same alleged crime. The courts interpreted double jeopardy as presenting three discrete rights to a citizen: an assurance that the respondent will not face a second prosecution after an acquittal, the respondent will not face a second prosecution after a conviction, and that the respondent will not be able to receive multiple punishments for the same offense. Evans was not acquitted of the original charges filed, but was actually acquitted for the added element of burning a dwelling, which was not an element of the original offense he was charged with. I want the Supreme Court to rule that double jeopardy does not apply to Lamar Evans in this case because Evans was acquitted of a non-existent element of the case. The state of Michigan should be permitted to retry Lamar Evans on the arson grounds to compensate for the mistakes made by the judge.
Counselor, a couple of questions. We talked about the added element at the trial court level. Do you feel that the state of Michigan is prepared to prove the remaining elements of the actual crime of arson?
Well,
what I'm saying is, in order, your statement is saying that there was an added element to the crime that
correct.
The prosecutors had to prove at that time. Is the state of Michigan prepared to a satisfactory level prove the other elements that are needed to convict?
Yes, they are.
Understand?
Yes.
Go ahead.
Well, the judge disregarded Michigan's proof that it was the acquittal was based on whether it was a dwelling or not. and he was acquitted of a crime that he was not. He was acquitted on the non-factual elements of the case, the added element, and Michigan never even got to prove whether or not it was a dwelling.
Thank you, Counselor.
Thank you.
Attorney for Evans, you have 3 minutes for rebuttal. Would you like to add anything? You may proceed.
The state of Michigan attorney says that Lamar Evans was acquitted for a different crime, but he was still charged for burning of a vacated house. And now the state of Michigan is still trying to charge him for that crime. And it says, shall any person be subject for the same offense to be twice put in jeopardy or life and limb in the United States Constitution, as I repeat myself, subject means charged, as an interpretation as many historians and interpreters of the Constitution have took. So, since Lamar Evans was acquitted of a different crime, he was still charged for the same crime the first time, and now he is being charged for the same crime the second time, which is, in fact, a violation of the Double Jeopardy Clause.
Counsel, what is your response to a question of whether the state of Michigan has a fair opportunity to try Mr. Evans, considering that on the initial trial there was an added element that was forced to be proven?
Well, on the added element, the state of Michigan couldn't even provide the proper evidence to prove Mr. Lamar Evans' innocence or guilt, in this case innocence. So I believe that the state of Michigan is not ready to charge Lamar Evans with this crime, and if the state of Michigan does win, it will be on account of mistake.
While I certainly understand and respect your opinion, again, do you believe that the state of Michigan deserves the opportunity to have their argument heard as far as the elements of the crime?
Well, like sort of what I said before, the state of Michigan didn't provide the proper evidence. So if you're not willing to provide the proper evidence and come prepared for the case, then I don't feel that you get the privilege on the same level as other people who have prepared equally, like Mr. Lamar Evans' attorney.
Thank you, Counsel. Attorney for the state of Michigan, 1 minute for rebuttal. Would you like to say anything? You waive rebuttal. In that case, thank you, counsels. We'll take this case under advisement. We'll now prepare for our second case of the day. Thank you. Attorneys for Arkansas Game and Fish Commission, are you ready to proceed?
Yes, sir.
Attorneys for the United States, are you ready to proceed?
Yes, sir.
Attorney, you may proceed.
Hello, my name is Trevor Dallaire, and I am representing the Arkansas Game and Fish Commission. In the early to mid-1940s, the U.S. government and the Army Corps of Engineers built the Clearwater Dam in the state of Arkansas on the Black River. They did this to prevent flooding of the low-lying areas of Arkansas. Starting in 1993 to 2000, the U.S. government, or the Army Corps of Engineers, sporadically released water from the Clearwater Dam. This action caused the low-lying lands of the Arkansas Game and Fish Commission, which is used for duck hunting, timber harvesting, and other things, to flood. This area covers over 23,000 acres. This caused complete destruction of the land's timber harvesting and hunting land. The issue is the government does not want to pay compensation for the destroyed timber and land. It has destroyed timber and land that promoted economic revenue. In a similar case, Lucas versus South Carolina Coastal Council, which happened in the year 1992, the Supreme Court ruled that the South Carolina land use regulation took away the rights of coastal landowners of any possible revenue from their land. The Supreme Court ruled that if the government is not allowing you to have economic benefit from the land that you own, it's the same effect as taking, which should be given for just compensation. I will open up for questions.
Yes, one question, Council. Is it your argument that the Arkansas Game and Fish Commission, they do not have any use of the remaining land as a result of the flooding?
Over the course of the 7 years, it sporadically flooded the land, which caused the timber to rot and be unusable. These trees were used for economic revenue from the commission itself. They permanently destroyed it, mm-hmm. which means that the government should give just compensation because they permanently destroyed the things on the land and destroyed the land itself for duck hunting.
Why did the government flood the land in the first place?
I cannot answer that question. I will get back with you on that one.
Okay. Flooding is a natural occurrence. Had the river flooded on its own, should the government compensate Arkansas?
If the river flooded on its own, it would not have been the government's fault. Due to the fact that the government created a dam in the mid-1940s, and then from 1993 to 2000 sporadically released water, destroying the land is the government's fault because they should give just compensation for that land that was destroyed.
Had the government not sporadically released water and the dam broke and permanently flooded the land, would the Arkansas still be compensated?
Cannot answer that question.
The dam is not in your state. Or it is in your state. Don't you think that your state and you should take responsibility for possible damages to the dam?
Can you please clarify your question?
Do you think that the dam is obviously not working at its best capability? Don't you think that since it's in your state, you should possibly take care of it?
It was not a state-built dam. It was a government-built dam, which means that anything that happens or water's released or any malfunctions, the government would have to come in, which is the Army Corps of Engineers, who is like managing the dam. They would have to come in and fix it themselves. It would not be on the state.
Is the government supposed to flood this land in the future?
No, they were not. This dam was built to prevent flooding, period, because of the flooding that had occurred earlier before the dam was even built. When the dam was built, it was meant to prevent flooding and not cause flooding.
Thank you, Counsel.
Thank you very much.
You may proceed.
My name is Case Van Rees, and I will be representing the United States in the case Arkansas Game and Fish Commission versus the United States. It has already been agreed on that the government is to blame for the flooding that took place annually over a 7-year period. Because the land affected was not targeted or permanently seized, a full taking is off the table. It is my goal to have a limited taking taken off the table as well. My associate representing the Arkansas Game and Fish Commission states that the land flooded is incapable of providing the owners revenue. Though the timber on the land was destroyed, the land is still capable of providing revenue. Like you said, hunting is one such activity that can provide sufficient revenue. Had the land been seized by the government would have received that revenue. Also, the owners of the land must be held responsible for the fact that there is an inherent risk to placing timber on land that was flooded more often than not prior to the building of the dam. In the 1940s, the Clearwater Dam was built to make the land more accessible, but it is still floodplain. If your income is based off timber that grows next to a river, you should realize that you are playing with fire, and when you get burned, it is nobody's fault but your own. Since that land is still capable of providing revenue, and flooding in a floodplain is a natural occurrence, the government should not have to pay money they do not owe.
Why did the government start the sporadic flooding from the dam?
There are many factors that control when and how much water to release from the dam. The specific reason I do not know.
Is the purpose of the American government to protect and serve its people?
Yes, it is.
Then do you think that the American government is doing its duty of protecting the American people by hurting these people in Arkansas?
There is no guarantee that the land will not flood because it is, in fact, floodplain. What the people choose to do with their land and how that may be affected by that land being flooded is not the government's responsibility.
But it is the government's responsibility for flooding the land, yes?
Yes, if it causes significant damage and makes land incapable of providing revenue, which it did not.
Well, you say it is not in this case, but do you agree that at this point, with the flooding, whether it's sporadic or permanent, it does limit the potential for income to be gained by the Arkansas Fish and Game Commission?
Yes.
Would you say that there is a greater cause? Obviously, with flooding a certain parcel of land, you're favoring another parcel. You're favoring some other cause over the land that the commission owns. What would you say in this case is the greater good, so to speak?
Could you clarify?
Well, when you're building a dam to redirect a river, you are preventing the river from flowing into a certain land, and you're favoring that land over the land that's being damaged by the flooding, correct?
Yes.
So, in this case, would you say that there's a greater good, or is it just done because the United States feels like this is what needs to be done in this case, in this land?
Well, I mean, the water must be released because one way or another, if it means breaking the dam or the water going around the dam, the water has to get down because gravity cannot be defied. The water has to be released at some point.
Would you think the United States would feel like there should be some kind of compensation if the land were previously owned by the United States and not owned by another agency or another entity?
I do not feel that compensation is owed because it is not the government's responsibility if land that is prone to flooding becomes flooded.
It is their dam, though. It is the American government's dam.
Yes.
So
yes.
The dam is their responsibility.
Yes.
You said that there was flooding prior to when they built the dam?
Before the dam was flooded, the land was much more often covered in water, but the dam was placed there in order to make the land more accessible.
Okay.
Not flood-proof.
So the Arkansas Game and Fish Commission chose to plant trees in this area that was flooded many times before?
Yes, it's not the ideal place to plant trees due to the danger of those trees becoming
So the
rotten.
owners were fully aware that their property had the risk of being flooded?
They should have, because that land was previously flooded almost constantly.
No other questions? Thank you, Counsel. Attorney for the Arkansas Fish and Game, you have 3 minutes for rebuttal. If you'd like to reply or waive your rebuttal, you may proceed.
Back onto what the case just said, it is the government's dam. It is their responsibility. There was a human entity there to release the water. Now, whoever gave that order, I do not know. But the reason we planted trees there is because we thought that with a dam there, it would not be flood-proof, but it would happen on a much lower scale. Let's take, for example, the Chattahoochee River and Lake Lanier in Georgia. We have the Buford Dam, which does release water at night because they just need to keep the river flowing. They do this because If they don't do it, then the dam will break and the land below it will become flooded. We understand that the dam does need to be opened up, and water does need to be expelled out of it. But when you flood a land for 7 years temporarily, when you're saying temporarily, and you flood it to a point to where timber is lost, land is lost, it's the government's fault, because they are the people who either gave the order, where something happened to where a malfunction happened to where they didn't fix it, that they should be paying just compensation for the lost timber and lost land.
Counsel, what is your response to the attorney for the United States claim or assertion that creating the dam actually gives you more accessibility to your land?
It does give us more accessibility to our land. It did give us an idea that we are going to be able to plant trees here. We're going to be able to have a fishing game commission here for sportsmen to come out and hunt and then harvest timber. But if you release water to a point to where it floods it completely, 23,000 acres, destroyed timber, destroyed land, then it would be you're taking it, because then you are taking that economic revenue that was there away from us.
From the way it seems, the flooding was started 50 years after the dam was built. Is that true, or had they been doing it?
That was
constantly?
True. They did start the flooding of the land and destroying the timber 50 or some odd years after the dam was built, mid to early 1940s.
Is the land still reusable, or is it completely destroyed to the point where no more money can be made off of it?
It is reusable, because you can always replant trees into the land, but it takes a very long time to harvest those trees to a point to where they are usable for economic revenue. So to answer your question, it is reusable, but it would take a very long time for it to be economic revenue to be harvested from that land.
Since you're saying that the land is reusable, are there not other ways for revenue to be made while you are waiting for your timber to be back up to full quality?
Yes, but like he said, that timber was only part of ours. It was only part of ours, but it was one of our major revenue building opportunities. The next major revenue ability to provide or to get economic revenue from it was the hunting, and that was only part of it. The timber was one of the major parts, along with hunting and many other small things.
So can hunters and fishers still hunt and fish after the land was flooded?
Yes.
Okay, so the only revenue that was completely lost was trees, is wood.
Yes, which was one of the major economic revenue things we use to get economic revenue from the land.
Okay.
No other questions? Thank you, Counselor.
Thank you very much.
Thank you, Counselor. At this time, we'll take both cases, both the Arkansas Fish and Game versus United States, as well as Evans versus Michigan, under advisement. United States Supreme Court now is adjourned.
All rise.
All right. Welcome back to WA Live, Court TV. All right, counselors, you heard the last two cases, Evans versus Michigan and Arkansas versus United States. Let's go to you first, Ms. Berthium. Give us your thoughts, if you would, on the Evans versus Michigan case.
I thought both lawyers did an excellent job of making their case. As we discussed before, I thought that the state of Michigan had a much harder job. And I do think that while they rose to the occasion, Evans's lawyer would seem to have responses for each one of their claims. They both did a very good job, but I think Evans will come out ahead in this case.
And why is that?
The state of Michigan has a difficult issue to prove. They have to demonstrate that a trial judge's error should be something that the state of Michigan is excused for. And I thought Evans's lawyer did an excellent job of explaining that even if there was an additional element of the crime in this particular case, his client would be charged with the same crime, which is clearly a violation of the Double Jeopardy Clause.
So you think the Supreme Court, as it's currently stated, is going to let clearly a criminal who burned down a building to go free?
I do. I think that while the current Supreme Court is obviously disturbed by the idea of letting an arsonist go free, they are more likely to be disgusted by the trial judge's mistake and want to express to trial judges across the country that they are going to be held accountable.
All right, very good. All right, let's turn to you, Mr. Batterman. And what are your thoughts on the Arkansas versus United States case?
I thought that both attorneys did an extremely good job of presenting their arguments. The representative representing the United States had a tough job trying to demonstrate that the government shouldn't have to pay back anything to the Game Commission for the destruction of its land.
The U.S. argument was that the taking of the land wasn't permanent. Were you persuaded by that argument?
I wasn't persuaded by that argument, but I thought the argument that was perhaps more persuasive was that the decision to plant timber on the floodplain was inherently risky. And even if the dam had not been released consistently, there would have been natural flooding that still destroyed the area. And so I think that that argument could be one that the court finds persuasive. I'm not sure that I would say that the court will decide that the federal government owes nothing to the Game Commission, but I do think that the government might have convinced the court to only require the government to pay a very limited taking compensation.
May I speak to that?
Yes, please.
I thought it was interesting. I thought the lawyer for Arkansas made an interesting point at the end that maybe could have been a larger part of his case.
Okay.
In response to one of the questions, he indicated that the dam was in place for 50 years before the government began flooding. And I really think that undercuts the United States argument that the Arkansas Game Commission should have been aware that they were planted in a floodplain. Really, 50 years after a dam has been put in place doesn't really seem like it's a floodplain anymore to me. And I imagine that the state of Arkansas Game Commission had a similar response. They planted the trees because they believed that the dam would continue working as it had for 50 years. It's a clear taking.
All right, well, what about the argument, though, that without the U.S. even building a dam in the first place, it would have been a floodplain just by Mother Nature, and you would have been able to plant trees there in the first place on a floodplain?
It's a reasonable argument, but doesn't apply in this case.
And why is that?
The government has did the takings of the Arkansas land right now. The fact that they would not have been able to plant trees there 50 years ago doesn't mean that they don't have an economic harm in the present tense.
Okay, so you believe that the government will lose in this particular case?
I think the Arkansas Game Commission will prevail, although it may be a limited award in their case.
And how would the U.S. Supreme Court rule on if it's not a permanent taking but a temporary taking? How does that work in terms of monetarily for the Arkansas Game and Fish Commission?
It's a difficult thing for them to decide, which is why I think, given the current makeup of the court, they're more likely to rule that it was a permanent taking. The takings clause is not about how often it's not about the taker, but from the perspective of the takee, which means that it doesn't matter if the United States only occasionally flooded the land, as long as the economic damage was permanent. And I think Arkansas proved their case there.
Okay. All right. Just this is a little bit for both of you now. What about the argument that the only reason why they released the water in the first place was to benefit the farmers who were downstream who needed the irrigation of that water? Or just answer it.
I think that, while it may benefit some of the farmers downstream, they are required to compensate those that it hurt.
All right. Thank you very much. We appreciate you tuning in to WA Live. We'll come back with the results at some point later in the future. Thank you.